Hi, thanks for joining me. I'm West Virginia civil rights lawyer John Bryan, and this is my sort of not really regularly scheduled Monday evening live cast called Freedom is Scary. I believe this is episode 16, maybe it's 17, I can't recall. I've been so busy today that I haven't even been able to collect my thoughts enough to just jot down what it is that I wanted to talk about. Might have at least one special guest join me here, but this past Friday, after 6 months after we posted this video of the family court judge searching my client's house, big news happened on Friday, and that was that the West Virginia Supreme Court released the official statement of charges against this judge that searched my client's house. And we were really satisfied with it, but it happened on a Friday, and I was traveling for jiu-jitsu reasons. So I didn't get really a chance until, at some point this weekend to really even read them. And here today, between the usual crazy Monday, I've done 3 different TV interviews for reporters wanting to know information about this case. So it's definitely big news in that media market, and they have 3 different TV stations, and I believe they all did stories on this, and some of them probably is their top story. And I haven't gotten a chance to see it because obviously I'm still at work. I'm here. Let's see. Let me turn that thing off. All right. So I have one special guest here. Let's see if our ghetto West Virginia internet connections hold up here. Hey, Matt, how you doing?
Hello, how you doing, John?
Good. Let's try it like this. There's different ways I can make you smaller and me bigger, but that works. Can you hear me all right?
I can.
All right. So this is Matt Gibson. This is my client in that case, and you might recognize him from these viral videos, though he's missing the sunglasses on top of his head this time. But I do still recognize you. Now, did you do an interview with the news today?
No, I didn't. I was tied up with a prior engagement.
Oh, okay. Yeah, well, I was forced to do several without you here, but I think I did all right. I don't know. I haven't watched it though. Did you see any of them on the news?
I heard through somebody was playing through the TV, so I heard what you said. I did read what was on Facebook though.
Okay. All right. So you'll see that I can put, if people can comment or ask questions, and I can put them up on the screen. So we already have been visited by a famous guy, Barry Goldwater here. He just gave you basically, one of these. So that's Barry Goldwater. We also have Aaron. Thanks for watching, Aaron. Jeff SR. And, basically it was, I've already scheduled something for next Monday night at the same time, having to do with that same county and some of the stuff that's going on there and what the people can do to fix some of the problems. So just to give some background, if you're not aware of what we're talking about here, it's going, I don't know, maybe 7 months ago or so, Matt came to me and he brought me this video showing a family court judge searching his house, and he had somebody videoing the encounter, but she was forced to turn it off. Matt also had a recorder in his pocket, and eventually the deputy who was with the judge figured out that he was recording it, and he was forced to turn that off as well. So at some point the footage cut off, but Matt is the victim in that case. So Matt, can you just kind of give us some background on what had been going on here? You had gotten divorced how long earlier?
Prior to the hearing, March 4th, probably about a year and a half.
Okay,
No.
so a year you get divorced, and about a year and a half goes by. And was there any activity in the divorce case, or it was just something popped up out of the blue?
No, it was a property exchange. It actually happened on November 30th, 2018. So everything was smooth. She picked the property up. About almost a year after that, then I got the contempt filed on me because we had words on a custody dispute. So almost a year after we exchanged property, then I got the contempt filed on me over the property.
Okay, and so the night before the hearing, you got a phone call from your ex-wife's lawyer. Is that right?
Yeah, and I don't know if you want me to bring up the year and a half prior to during the custody, or I'm sorry, the property exchange. What Mr. Lusk had said.
What you're talking about back when the divorce, a year and a half earlier, when the divorce was still ongoing?
Yes, sir.
What? Yeah, I mean, sure. What did he say?
He had said when we were doing the property exchange that I'm gonna paraphrase. He says, "I'll just go get the judge, the deputy, and we'll search your house if you don't give her all the items." Now that was a year and a half prior to actually searching my house. So
Okay, but that never occurred at that time.
No, it didn't. That was a year and a half prior to the actual search. So then fast forward to March 3rd. March 3rd is when he called the house and offered me, that I wouldn't have to go to court if I pay him $5,000.
And so March 3rd, that being the night before this video occurred, but the night before this search occurred. Is that right?
Yes, sir.
Okay. I take it that you didn't pay him the $5,000.
Not one penny.
Okay.
No, sir.
Okay. So you arrive at court the next day, you didn't pay the $5,000, and you're representing yourself at that point. Is that right?
Yes, sir. I sure was.
So how did it go from you have this hearing on this petition for contempt to, all right, the judge is searching your house?
So
just in a nutshell.
In a nutshell, when the hearing started, she didn't have the property form on file. So she tells Mr. Lusk, "Hey, I don't have a property file on file." And he says, "Well, just use this one." Well, that property form was altered. It had a bunch of handwriting on it. And I get it. I look at it, and she starts to ask me some questions. Did you do this? Did you give her that? Did you give her this? And one of the items was pictures. And I said, "No, I didn't give her the pictures because they were already ordered to me, and I had copied the pictures prior to." So yes, she did get the pictures. Okay. So she said, "I don't believe you. We're going to go to your house. You got 10 minutes to get to the house." Okay. So those pictures were awarded to me on the April 2018 hearing. That's also in court recorded audio, and by the April 2018 order. But she didn't go back and review her own order that she awarded me those photos. Okay. So when they come to search my house, that's when they took things that were not on that property form. And that property form was altered. It had handwriting on it, and it was made look like that I signed it. Well, the property form that I signed only had 2 words, grill and dog. The rest of the stuff was altered, added to. And
so the list of items that was in dispute here, this is something that you guys had agreed on in the divorce. Is that right?
Yes, sir.
These were the list of personal possessions that it said what items you were going to take and what items your ex was going to take, right?
Yes, sir. That's it.
So now a year and a half later, her lawyer's claiming that you hadn't provided all the things essentially that you were supposed to provide, right?
Sure. Right.
And then the judge just says, "Well, we're going to go to your house and see."
Exactly. And, just like the statement of charges said, she didn't tell me why we was going to my house. So there was no way for me to object to it. So when I get to my house, there's a whole different ball game. Of course, she read the statement of charges.
So is that why, if you watch the video, that you can be? I mean, you said something like, "I need to know what you're looking for," I believe is what you said.
Exactly. And she wouldn't let me talk. And anytime I would say something, she would say, if you don't let me in, I'm going to send you to jail. Now, here's something that wasn't really put out on the video. Not only did she show up with a bailiff, the opposing attorney, my ex-wife, she also brought my ex-wife's boyfriend, her dad, and brother. So in a closed family court hearing, because all family court hearings are supposed to be closed to the public, she brought along a crew with her. Her a boyfriend, her father, and her brother, along with the opposing attorney, deputy, and of course my ex-wife.
But I mean, something she didn't bring was a court reporter, I believe, right?
Yeah, the most important thing, it is state law for all hearings are supposed to be recorded. That's why I was recording.
And I think the Judicial Investigation Commission pointed out that, all right, well, if this is a just a part of the hearing, if we're just doing a viewing or a home visit, then there were no written rules describing how this would go down, so you know what you're dealing with. There was no court reporter brought, and there wasn't even an order that was ever entered describing what took place at your house, was there?
No,
At that time?
no, at that time, absolutely not. No, sir.
Was there ever a list of what items were actually taken out of your house when the judge let your ex-wife and her lawyer in?
They made a list, meaning Judge Dorsey, after Judge Golston was disqualified, Judge Dorsey went back and reviewed what Golston had talked about when we got back and made a semi kind of list. Now, mind you, they took out of this house my girlfriend's DVDs, my kids' DVDs. They took things that were not on this order. So,
Okay. But
you know, that
but say like when the police are executing a search warrant, they would make a list like, all right, we took digital scales, we took a pound bag of marijuana, we took 2 cell phones, and name the manufacturers, and we took X, Y, and Z. They by law they name all these things. When these items at the time that they were removed, was there ever any documentation of what was taken out and what was not taken out?
No, sir. It was basically it's a smash and grab. They went and grabbed what they wanted. Matter of fact, it's indicated in Judge Dorsey's dictation of what Golston had spoke about it after she returned, that there's a missing chainsaw. And by court recorded audio, the bailiff was supposed to call me and let me know when he was going to bring the chainsaw up to the courthouse so I could come pick it up. Well, 7 months later, I still don't know where my chainsaw's at.
Okay. All right. I'm going to take you off for a second, and then I'm going to go over what the JIC charges. So, I mean, you're free to stand by. I can bring you back on, or you can go do whatever. But I'm going to put you in the virtual green room here for a few minutes.
Cool.
Okay. So on Friday, the statement of charges came in they were released by the West Virginia Supreme Court. And these things only get released if it gets to this level, because if they find that nothing wrong was done in their opinion, or if they're just going to do like a written reprimand, for instance, it doesn't necessarily ever get disclosed. It's all confidential at that point. So clearly they decided to move forward in this case with the statement of charges against the judge. And this comes from the Judicial Investigation Commission. And that's sort of just like the disciplinary investigation function for judges in West Virginia. And probably a lot of states have a similar sort of thing. When you're talking about a sitting judge, there's really only 2 things that can be done. One is the legislature can impeach a judge, but our legislature hasn't been in session for 7 months, and they won't be in session until February of 2021. The other thing that can happen is what's called the Judicial Investigation Commission. It is sort of a state agency that investigates judges. And if, you can file complaints with them, anybody can file complaints. And when you do, they have a mechanism where they review those complaints and they look at it. And sometimes they interview the judge, and if they think it's unsubstantiated, which probably the vast majority of them are, they proceed no further. But where they believe that there's probable cause that serious violations have occurred, then they file this thing, and it's called a statement of charges. And it basically orders the judge to respond in writing, and it ultimately goes to the Supreme Court. And ultimately, the Supreme Court decides whether or not they are going to take disciplinary action, which could be anything from suspension off the bench through, I suppose, written admonishment if they wanted to. Though they could have done that without using this process. Just real quick, if you look at the website, our website, thecivilrightslawyer.com, I posted in full the statement of charges that was released on Friday. I think I can put it up on the screen here. Okay. All right, there's the website, civilrightslawyer.com. If you go to, let's see, not the last post, you can see I wrote a lot this weekend after I sort of was able to digest what was in this document. So there's if you haven't seen the original video, it's there. You can watch the original video from like 6 months ago. And then you can watch the one part 2 that I just did the other day. And there definitely is going to be a part 3, and it's not completely ready yet, but we're working on it behind the scenes. But right between these videos, you can see I linked to this. This is the formal statement of charges, and can you all see that? I don't know if it's not zooming in like I asked it to. Let's see. Maybe if I go directly there. All right, it popped up in a new screen, so I need to share that one. All right, so let me remove this one and create another one. All right, there it is. Can you all see that? All right, formal statement of charges. That's it. All right, so Supreme Court of Appeals, West Virginia, that's where these things are filed. It's a formal statement of charges, and this is pretty interesting. So the Judicial Investigation Commission found that all these different rules were violated. So judges have rules of professional conduct, basically, just like lawyers do. And there's a lot of them, and some of them are sort of vague, but here we go. Rule 1.1, 1.2, 1.3, 2.2, Rule 2.4b, Rule 2.5, Rule 3.1a, b, and d. So there are several rules that they're saying was violated here, and so basically the way I see it, and this is a 26-year judge, but basically they are. I mean, you can read it this way. So according to the JIC, the judge failed to comply with the law, committed actions which undermined confidence in the judiciary, abused the prestige of her office, was impartial, unfair, allowed external influences on her actions, was incompetent, undiligent, uncooperative, and engaged in extrajudicial activities. Most importantly, if you read further down on this document, you'll see that this has gone on for 20 years, according to the JIC. So these sort of home searches, or as she calls it, home visits, have been happening for 20 years now. And they found that it had happened in 10 other occasions, at least, and that in all those other 10 occasions, attorneys were involved on both sides. And that in none of them did the attorney for the poor guy who got his house searched by a judge even object to what was happening. And that's just bizarre to me. I did 2 or 3 TV interviews with local news stations today, and that was one of the things I brought up, is that other lawyers have already contacted me across the country who have been following this case, and that was kind of the thing that shocked some of them the most, was that this happened 10 other times according to the allegations, perhaps more, but at least in those 10 times, the guy or the girl was represented by an attorney and they didn't object to it. So why in the world would you not object? Imagine you're in court and the judge says, all right, we're going to go search your client's house now. And you don't object to that? Like, why would you not object? So that's the rest of it. You can find it linked on my site at thecivilrightslawyer.com. Some of the the gist of the allegations were, let's see. All right. Over the past 20 years, she's engaged in this practice of visiting home litigants at their homes who are of people who are appearing before her. And they found at least 11 separate occasions where this happened. And the investigator, when interviewing the judge, as they mentioned in the statement of charges, asked the judge, was there any legal basis for you doing this? And it says, when asked, the respondent, meaning the judge, could provide no statute, rule, or case that gave her the authority to conduct home visits. Respondent also acknowledged that there was nothing in the contempt powers that gave her the authority to conduct the home visit. So that's part of what was being alleged here, is that, well, it was a petition for contempt. A judge can do a lot with their contempt powers. So if they can have you arrested with their contempt powers, why not do what they did in this case? The problem with that, and there are some problems with that, is that there was no finding of contempt, first of all. So it's impossible. There was no finding of contempt. And in West Virginia, you are allowed the opportunity to purge that attempt before you are punished for it. So there was no contempt power being used. The best argument for the defense here is that it was some sort of home visit and, part of a hearing, which is, kind of what they said. But the problem with that, as the JIC pointed out, is that there was no court reporter even brought. There was no order done after the fact reflecting what had happened. And there was no set of rules, establishing what the ground rules are for, a home visit like that. And also, as they point out, as Matt said, he wasn't told why the judge was coming to his house or what she was looking for. He wasn't given an opportunity to object to it. And so there's, the claim that it was part of a court hearing is extremely weak. And that's kind of the case that the JIC made. So if you go to the website again, you'll see sort of my thoughts in the latest post on what's going on there. Let me bring Matt back on. All right. You still hear me, Matt?
Yes, sir.
Could you still hear me that whole time when I had you in like the green room?
Yeah, it's kind of cool. The soda's no good. It's flat.
Did you see anyone else in there?
No, I'm just by myself.
Yeah, I can send a link. I could just blast it out to everybody. We'll see who else shows up in there.
That'd be all.
Did I get that right as far as the the facts as you recall them? You
Yes,
weren't told what she was looking for. You weren't given an opportunity to object. And
nope.
Did you recall at the time, a year and a half earlier, when the opposing attorney had threatened to do this very thing to you?
I heard him, but that day was the final divorce. So to me, it was everything was a blur. It didn't really come out of my mind until after it happened. That's when I found the video, and I was like, oh my gosh, he just threatened me to search my house a year and a half prior. Then he does it. That's amazing. This dude, this opposing attorney, had a gall that he'd go get the desk and not do a motion, not do anything, go get her and the bailiff and go search my house. That's how much they've done this. Since this weekend the charges dropped, I've been reached out to by numerous people, saying how their house was searched, and it's basically a pay-to-play scheme. So it's for sure wasn't just me.
Some of the comments here. Let's see. A couple questions here. Chris asks, "Is this legal to force them to stop recording?" So you had somebody else filming the video, right?
Yes, sir. She was doing a video, and I was doing audio.
So you had audio going in your pocket.
Yes, sir.
All right, and I know we have that audio, but tell us kind of what happened and how long it went until they found out that you were recording audio and what they did to turn it off.
I'm gonna say a few minutes. I'm not really quite sure. It was a few minutes for sure. My girlfriend was on the upper driveway filming down, and I had that phone in my pocket, and Mr. Lusk had told Judge Golston, he's the one that alerted her that I was recording, and she asked me, and I told her, yeah, I was recording, and she told the bailiff to go ahead and seize my phone. I told him, no, don't seize my phone. He thought about it, then he stepped back and called for assistance. And she said, now, are you going to give him the phone and let me in, or are you going to jail? So I had to make a choice: lose my kids, or let her in.
All right. So, I mean, you relented. So, I mean, it sounds like you felt like you had no choice.
Absolutely, there was no choice whatsoever. She threatened me 7 times with jail time, and when he stepped back for assistance, I know what it's like when a man steps back for assistance. He's not trying to give you a hug. So I knew right then, if I don't let them in and go to jail, they are going to do a order right then to seize my kids, take them away from me. I go to jail for the night, I bond out, then I got to hire an attorney, and who knows how these attorneys are, because this is against a judge. This whole Raleigh County is nothing but collusion. So I don't know how it would have shook out. It might have been a year and a half before I got my kids back. I'd had to pay child support. It would have been stupid time for sure.
So when she threatened you with arrest, you knew that she wasn't going to be the one arresting you. It was going to be the cop standing next to her with handcuffs.
Exactly.
Right?
Now, yes, sir. Now she was barking. I mean, I'm sure she's made many arrests in her time, but that was a joke, of course.
So, all right. The question from Chris is that legal to force him to stop recording? I mean, first of all, he's on, when this happened, correct me if I'm wrong, but you're standing literally in your front yard, right?
I'm in my front yard on my property. Yes, sir.
Right. So, I mean, in my opinion, I think this is both common sense and the law is that no. I mean, I don't see how it would be legal to force somebody to stop recording in their own front yard. Now, if you really are in family court, there really is a rule in the family court rules of procedure that you're not allowed to record. You make your own recording of what's going on in there. So if they have been in a family court, then it would have been legal for her to require him to turn his phone off. But I mean, they weren't in family court; they were standing in his front yard. So I don't see any circumstance of how that could be legal. No, I mean, and it's kind of common sense. I don't know that you need to even and point to anything. I mean, you could say First Amendment, and that might be a separate First Amendment claim. There is he's trying to record what's happening, and he's forced to turn it off. That also brings up the other issue of, it is a gray area of whether or not you can record law enforcement in a public place. And that's an issue that needs to go to the Supreme Court. And I don't think it's been decided by our federal circuit, the Fourth Circuit. The First Circuit in the Glick case, they did find that there's a constitutional right to videotape police officers in a public space in the First Circuit. But I don't believe it's been decided in the Fourth Circuit. But there's a lot of authority that's persuasive that even in a public place that you can record as long as you're not interfering with whatever's going on. Now, there shouldn't be any dispute that you can do that on your own property. I mean, I think that's one of the things that people have reacted to here that is just, it just sort of smacks of government tyranny, that here we're going to stomp all over your rights and you can't even record what's going on, not even surreptitiously in your pocket. So yeah, I mean, that's my question. I don't know if that's even an answer. Jeff, tyranny, I would agree completely. Judges can do what they want, even more than cops. I mean, absolutely. I mean, there was a case, one of the cases that I came across in kind of researching what the law was behind this situation. As you know, judges have absolute immunity, and you think qualified immunity is bad when you're trying to sue police officers. Well, absolute immunity is the best immunity to have, and it's almost impossible to get around. In fact, there is a case that I came across where a judge ordered her bailiff to go seize a lawyer who was in like the courtroom next door. So it was in the same building, but he was in a different room. And she actually told the bailiff, "Go seize that lawyer, and when you grab him, I want you to use excessive force." And so he did that, and he did use excessive force. And that lawyer later sued the judge, and 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 the bailiff in that case tried to claim that, well, since the judge ordered me to do it, I should have absolute immunity, just like a judge. And the court found that no, you just have qualified immunity, even if you're doing something that a judge orders you to do. So one of the takeaways from this area of the law is that if you're a cop, you can't just do what a judge tells you to do and expect to receive the same immunity that that judge does, because you're still only going to have qualified immunity. So it's not going to protect you at all. So it'll be interesting to see if out of this situation, if we get any clarification on the law of what judges can do and what judges can't do. The problem here is she really wasn't even acting in the capacity of a judge, as the JIC alleged in the charges, and as she really admitted to them, she was acting as a litigant. So she stepped down out of the role of an impartial and fair judge and stepped into the role as basically the lawyer for the opposing party. And that is, I mean, a big no-no, obviously, if you're a judge. So that might make a difference in the litigation, where one of the ways that you can lose absolute immunity is stepping out of a judicial role and into the role of something else. Or you're acting in complete absence of any jurisdiction whatsoever, which is very, very rare, because judges have, as long as there's some underlying pending case, there's usually at least some jurisdiction. Let's see. Some of the other questions. Let's see. I'm curious, what was the judge's bond? So these aren't criminal charges. These are administrative type charges that are, it's like disciplinary proceedings for judges, just like they have disciplinary proceedings for lawyers. So you get, removed or suspended or whatever the case may be, is the punishment, is the relief that they can give. They can't put anyone in jail. So while they can remove her from the bench or discipline her as a judge, they can't put her in jail. So therefore, there's no bond, because there hasn't been any criminal charges. In fact, that's sort of what I'm going to get at next Monday when I have a special guest on here out of that same county that might discuss some of what's been going on there, because where you have something like this happen, it doesn't happen in a vacuum. Just as you were saying, Matt, there's been crooked stuff going on in a place like this for a long time. I mean, she's been on the bench for 26 years, and the lawyers in that county, some of them went on the news basically sticking up for her, saying that this is completely legal. We do it all the time. Clearly, the state disagrees. The people who are in charge of judges disagree with that, and they named several serious rule violations that, if it happened, which it did because it's on video, that it violates. So where something like that happens, I mean, there's going to be other problems there. So who has the power? Who has the power to file criminal charges against somebody like this? That would be the county elected prosecutor. It's my understanding that the elected prosecutor in that county, in fact, I think, don't quote me on this, but I believe the lawyer that was involved here is a big donor to the campaign of the prosecutor in that county. That's what I was told. So, as with any case, you start following the money trail, and you might figure out why there's so much injustice in a particular court system. So, will the prosecutor, who has the sole power, really, to at least on the state level, to file criminal charges for arising out of what happened here, will that ever happen? So, where you have a connection between the events and the person who has the decision to file charges, I think I probably wouldn't hold my breath that prosecutor is going to file any criminal charges. And being that it's an election year and that prosecutor's up for election, I think that's something that needs to be discussed. And if I lived in that county, that is who you address that question to, is the elected prosecutor in that county. What is the bond going to be? Are you filing criminal charges? And I have no power to file criminal charges. The state Supreme Court, through the JIC, has no power to file criminal charges. That leaves just the county prosecutor there, Raleigh County, West Virginia, or it leaves federal prosecutors, of course. So federal prosecutors, much like you had that Judge Michael Thornsbury, who made national news by getting indicted federally while sitting as a circuit court judge. The feds could do something here. So, I mean, there's a couple people who could make that decision, but I'm not one of them. Matt's not one of them. The JIC is not even one of them. So, who knows? Only time will tell as to whether or not there will ever be a bond or any criminal charges arising out of what happened. And another good point is that this investigation commission only investigates judges. So they didn't investigate any lawyers. They didn't investigate the law enforcement involved at all. And that was just not even something that they do. So there's been no investigation, to my knowledge, of the law enforcement at all. Again, that would be something that prosecutors would do, or more likely, it's just going to be something that I do in the realm of a civil lawsuit, when I can file a civil federal rights lawsuit, and then I can place individuals under oath, take their deposition, and find out the facts, issue subpoenas, and things of that nature. So they will be interesting to see when I finally have access to the facts, what the deal is with the law enforcement who, it wasn't just a judge doing this. You had a police officer, and that's the guy who had the handcuffs and the gun, the ability to call backup, that was forcing Matt's hand and allowing them to go in the house and agreeing to turn off the phone, all that stuff. Well, not that you agreed to turn off the phone, but I wouldn't call it voluntary in any event. Let's see. All right. It looks like a good comment here. In its decision in Fields versus City of Philadelphia, the Third Circuit Court of Appeals panel said the First Amendment's protections extended to two people who use their smartphones to record police. Yeah, I mean, again, we're Fourth Circuit. We're not Third Circuit. I do think there is a First Amendment issue here, regardless of whether or not, even if he was on public property, say just in the road in front of his house, and we still might have a good First Amendment claim here, or a good First Amendment issue. But here, he's on his private property. So, we'll see what happens. But I think there's Fourth Amendment violations here, and then there definitely could be First Amendment violations here. Thomas, maybe you live in Raleigh County. He says Raleigh County is as corrupt as they come. And Thomas, if you live in Raleigh County, then you can make phone calls right now. I mean, this is election time. I told you who it is that has the power to do something here. The Supreme Court. I mean, the JIC. I mean, they're doing their job. They actually opened investigation of this judge the day after I originally uploaded the YouTube video. I mean, in the days of government inefficiency and incompetency, this really has been a shining beacon on the hill of government doing what they're supposed to do and doing it well and doing it quickly, even during all this coronavirus stuff. So you also, Thomas, you're going to want to be here next Monday, same time, 6:30 p.m. for a special guest that you're going to want to hear from. Absolute immunity. That's correct. So there's no doubt that in a civil lawsuit here, no matter what happens with the disciplinary stuff, the judge is going to have absolute immunity, and it is not easy to get past absolute immunity. Not easy at all. Done a lot of research on it. Like I said, there's the one case where the judge, see, there's not a whole lot of cases. I haven't found any cases that were exactly like this, where a judge actually went in someone's house and acted like a law enforcement officer and searched a house. Because as I said on TV, on the news, that's not what judges do. That's why I've never really heard that before. That's why there's no cases out there that state that. Because if it doesn't happen, it's not going to happen in enough frequency to make its way into these court decisions. So there are cases out there about the absolute immunity of judges, but they're usually situations where, the plaintiff is just feels like he got defrauded in the process as a whole, and that the judge, was engaged in this conspiracy with the other party. I mean, something like that. It involves the judge sitting at the judge's bench or writing from the judge's office. It doesn't involve, really, as the JIC termed it, extrajudicial activities, and that's sort of what the facts appear to be here. There are a lot of cases on absolute immunity, and I suppose I'll get plenty of time to compare them and write about them, down the road. But there's basically two ways of removing it. One is for a judge does not receive absolute immunity for what are quote non-judicial actions. So actions not taken in their official capacity. Now, what does that mean? Now, if she acted like a litigant here, and that's what the JIC said, I think that's a good case for not being in a judicial capacity. The second way that judges can lose absolute immunity is acting in the complete absence of all jurisdiction. And like I said a few minutes ago, that's almost never the case, because as long as there's some underlying pending case, that's at least some jurisdiction. But in other words, if a judge who just happened, if a guy who just happens to be a judge one day, like he comes out and accosts you on the street and beats you up, and later when you sue him, he tries to claim judicial immunity. Well, it had nothing to do with his job. There was no underlying jurisdiction. So it wasn't a fight in a courtroom where the judge was actually presiding over a case or something like that. It would have to be something completely unrelated. So the only real way that you get through absolute immunity in any realistic case is where the judge leaves that judicial capacity and enters some other capacity. And again, I think that it's going to be allegations similar to what we have here. Most of the cases out there deal with prosecutors, and prosecutors have certainly been sued a lot more than judges have. And so prosecutors also have absolute immunity, but they get knocked down to qualified immunity, just like a police officer, if they're acting like a police officer. So if they go out and, for instance, execute a search, then a prosecutor. Now, it's not that far of a reach for a prosecutor, because they are partisan and they are a litigant, to be involved in a search. But if they become an investigator or become a law enforcement officer, they may only get qualified immunity and not absolute immunity. But it's still pretty rare for judges. 7 here. Since judges, prosecutors, and police are separate entities, supposedly the cop, officer, or bailiff needs to uphold that oath, in my opinion. Well, how many people involved in this had taken an oath? You might not realize it, but lawyers take an oath. Before I was allowed to spend 1 minute as a lawyer, I had to take an oath in every courtroom. So the first courtroom would be like the circuit courtroom. And then the state Supreme Court, you had to take an oath there. The federal district court had to take an oath there. The federal appellate court, the Fourth Circuit in Richmond, had to take an oath there. So the lawyers take an oath. The judges obviously take an oath when they become a judge, as we watch the Supreme Court justices take oaths, and the police officers take an oath as well. So yeah, I mean, I think that's everybody involved in the process except for the litigants. Now, Matt himself has taken an oath because he's involved in law enforcement, but the usual litigant has not taken an oath. I mean, he's really the only person that hasn't taken an oath. So I don't see how anybody involved in that process is upholding their oath if they're allowing, this type of behavior. No, that wasn't really a question, but just a statement. But I think it was a very good point. Chad actually responded to you. I filed with the attorney disciplinary board, and the judge's version, nothing was done. They said they did wrong, but no recourse. So they probably get so many different complaints that they're going to take the stronger complaints. With the lawyer disciplinary complaints, believe me, I mean, people will file a complaint on their lawyer for the stupidest of things. I mean, absolutely stupid things. And you know what? If you get a complaint filed on you, you have to respond. And you know how long it takes? It's not the fault of the investigator folks, because there's so many of them. But by the time it sorts through the process, I mean, you're looking at like a year later by the time you get an up or down vote on that. And that's frustrating for everybody that's involved in both the legitimate cases and just the stupid cases. Now, that didn't happen here. The judicial complaints, I don't know how long it usually takes, but I'll tell you what, they jumped on this one, and I was, I've been really impressed in how quickly they jumped on it, and that they did it. Your gut feeling is always that there's going to be a cover up, or like you said, that they're going to say, they did wrong, but there's no recourse, something like that. Well, I mean, they are, I think it's because this really just goes to the integrity of the judicial system as a whole. And the point I made to the reporter earlier today was, just because you're in family court doesn't mean that the rules don't apply. So let's imagine that we're in a criminal court. In a criminal courtroom, you're a defendant and you're charged with anything. I mean, let's give a good example here. Say you're charged with felony grand larceny. Okay, something was stolen that is worth over the monetary threshold that makes it a felony instead of a misdemeanor. So let's say it's a $5,000 camera, or no, it's a drone. It's a sweet new drone. It goes 75 miles per hour, and it's pretty badass. It's a drone. It costs $4,850, and you stole it. You stole it from this guy. He deserved it. I mean, you hated the guy, and you felt like it was the right thing to do. Whatever, you did it. So you stole the drone. It was a $5,000 drone, and you get charged with it. It's a felony level, so you're charged with a felony, and you're in a jury trial, or you're in a bench trial, whatever. You're sitting in court, and you deny stealing the drone, or even you don't have to. So the judge just says, all right, Mr. Bryan, well, we're going to go over to your house right now, and we're going to look in your house. We're going to search your house to see if you have that drone at your house. And we'll be there in 10 minutes. And the bailiff comes and the judge comes, and they search the house and they find the drone. Well, how many, you could name the amendments in the Bill of Rights that would violate. I mean, we all can understand why a judge in a criminal case wouldn't go search the house of a criminal defendant before him, because we have protections built in to the system. I mean, we have the Fourth Amendment, for instance. So we understand that was something that law enforcement should have done by getting a warrant before you got into court. So if law enforcement believed or prosecutors believed that I stole the drone, they could go to a judge or a magistrate and they could swear under oath facts that they argue is sufficient probable cause to believe that I stole the drone. Then they get a search warrant. Then they can search my house to see if the drone is in there. And that was a lawful search. And that they followed the rules set out in the Constitution and that are set out in our case law. But here that's not happening. So that could have happened had the rules been followed. So the fact that we're in family court, it doesn't mean that the Constitution doesn't apply to you. And so you still have due process rights. And there was no due process here, as the statement of charges pointed out. I mean, he didn't even have a lawyer. There was no chance to object. He wasn't told what they were looking for. There was no court reporter. He wasn't allowed to record it. And I mean, there was no process to it. As far as it wasn't due process, I mean, there was no process. It was basically, what I would refer to as an anal probing by a judge. So did it kind of feel that way to you, Matt, at the time?
I think it was worse. I think I had hands on my shoulders. It was that bad.
Yeah. Well, I know that it was as much of a tough guy as you are. It did sort of, it did affect you. Am I right? I mean, it's what's it? Well, let me ask you this: what does it feel like to have a judge come to your house, search your house, threaten to arrest you, and bring your ex-wife and her lawyer in her house? I mean, what were the feelings that left you with?
It was almost unbelievable. I'll be honest with you. When I was driving over here, I've got some real close friends of mine, and their dad used to be a judge. And he says, "Look, Matt," he says, "I'm gonna give you some advice." That little blurb I had read to Judge Golston was from him, and he said, basically, tell her she's going to be in the witness capacity. That was from a retired judge, and I had about a 10-minute short drive to come up with that, and I'm trying to drive, and I'm freaking out because I'm like, "Are you kidding me? I ain't never heard of nothing like this. Never search no house without a search warrant. Never, ever, ever, ever." That's like the first thing you learn, right? So the feelings was unbelief. My head was spinning all the way through this. Anytime I would say something inside the house, she would say, "We're not going to talk about it. Shut up, be quiet." And what I didn't realize, and I know we didn't cover it, so I won't spend too much time on it. But what I didn't realize is the police officer sees my cell phone to only use his own personal cell phone. And we will talk more about that soon. But just my feeling was really unbelief. Crazy, to be honest with you.
Yeah, Mark says they didn't even use lube, basically. All right, we'll move on off of that. Judges have unchecked power. Juries were to be that balance. I mean, that's just why it's important that there is oversight over judges, and that this is not the usual case, because most judges, I mean, they're following the rules because, for instance, in criminal cases, you have court reporter writing everything down, and there's consistently appeals in those cases, so they're going out of their way to follow, in theory anyways, to follow the Constitution. In practice, though, if you've ever practiced any criminal defense, you know that the prosecutors, they have it easy. I mean, it's a piece of cake to be a prosecutor. You get everything you want. The judges they grant all your motions, and the defense is always an uphill battle. You never get what you want. But it's not like this, though. No, family court, I think it has its own danger because it's viewed as a less formal, more relaxed. There's a lot of pro se litigants, and here we are. But we have to remember that there are still rules, and I still haven't heard of anywhere else in the state, or much less the country, where this sort of thing was going on, and it was going on there for 20 years. I won't repeat that comment. All right. 7-8ers, can you sue the judge on a personal level? Yeah, that's what I'm talking about, absolute immunity. So in federal court, when you file a 1983 action, you're always suing the individual. You're never suing the state or the county or the city directly for the specific acts of civil rights violations. You always have to sue the individual. So the defendant is officer friendly, for instance, as an individual. And then his employer defends them and pays judgment, whatever the case may be. Under some circumstances, you can sue a city or a county, not the state, a city or a county in federal court. But that's a different claim. That's more of a pattern or practice claim. That's called a Monell claim. And those are much more difficult to prove because you have to prove, the ongoing policy or established practice of civil rights violations. Federal courts and the Justice Department have recognized the right of individuals to record the police. That's absolutely right. In fact, I used to share this memo from the DOJ that specifically they took the position that in the Fourth Circuit, the DOJ takes the position that there is a right to record police in public. Now, I'm not sure if the current DOJ has issued a different memo than that, but that is a good source when you don't have federal appellate opinions in your circuit. And Fourth Circuit, last I checked, didn't, but it's been a while since I've had any reason to look that up. Does the judge have immunity outside her jurisdiction of being outside her courtroom and scope of her duty? Well, that's sort of what I went over already. Once you leave a judicial role and enter some other role, then you can lose that absolute immunity. Or if you completely act with no jurisdiction at all. And I don't think that's this case because there was a pending case. So it's gonna turn on whether or not she left the judicial role and entered, say, the role of a litigant, which is what she's alleged to have done. Does a judge outside the courtroom still have authority? Now, I have tried jury trials and circuit courts where we have left the courtroom and we've gone to a specific location. This happens, for instance, in murder trials where the jury wants to view where the murder occurred, for instance. I've done it in several times in right-of-way cases because if you're trying a right-of-way case, an easement case in front of a jury, it's a totally different viewpoint once you actually see it yourself. I mean, you can put all the pictures you want on the screen of what the road looks like or of what the boundary looks like. You can use Google Earth, but actually being there in person it can be a game changer. So either party can make a motion for basically a jury view as a part of a jury trial. And when that happens, everybody goes, the court reporter, the bailiff, the jury, the lawyers, and you basically act just like you're in the courtroom. There's no improper discussions. There's no talking with the jury. The jurors they don't talk to each other about the case. You follow the rules. The court reporter makes a complete record of what happened. So that, it's pretty rare, but that happens. And there are provisions pertaining to that. And that, again, that's a jury view. I suppose a judge in a bench trial could do the same thing in circuit court, but there would be a process to follow that. And I don't think it would happen if everybody didn't agree to it. I don't think I've ever been on a jury view where somebody said, like, no, you're not coming onto my property without a warrant. I don't think it would happen then. That's something where, assuming you have everybody, whoever the property owner has given permission for everybody to be there. I don't think it would happen at all if there wasn't permission to be on the property. Now, it might be in a certain case that, the property is owned by one of the parties and they made an objection to a jury view occurring at the property. And that would definitely be a closer case if that's what we had here. And that's, I think, why the JIC pointed out in their statement of charges that there was no process like that followed. There was no court reporter there. There was nothing put on the record beforehand. There wasn't even a motion by the other lawyer or any lawyer to go there. It was just the judge basically on her own said, all right, well, we're going to your house. We're going to be there in 10 minutes. So it's just not that case. That would definitely be a closer case in my opinion. Let's see. Thank you for your detailed answer. You're welcome. All right. Good question, Tim. Are those judges they're elected? Yes. All the judges in West Virginia are elected. Even the Supreme Court justices are elected. Now, if there's a vacancy to fill, the governor will fill vacancies, but that's just, that's just where there's an immediate vacancy. So yes, all judges are elected. That's why they're very difficult to remove. What's the main way that you remove an elected an official? That's impeachment. Now, there's this other special way because the judicial system is very important and it has to be safeguarded, that judges can be removed by this commission on the Supreme Court. And that's what's happening here. And there was actually another judge that they did the same thing to, that they filed a statement of charges against in this same county, like last year, maybe it was 2019. It was a magistrate judge. And it really wasn't all that different from what we have here. It was a judge improperly inserting himself into personal matters or private matters. It had to do with searches, maybe that search of a residence too, that I recall, though I don't think he did it himself. He had ordered a trooper or something to do it. I don't know. You can look it up. It was a magistrate named Massey out of the same county. And like I said, it's not necessarily a coincidence, because where you have activity like this that's been going on for 20 years, it's probably a safe bet that there's more of it going on. What are the penalties for not upholding their oaths? I don't know. I don't think that is, they're not going to make a finding that you broke your oath and here's your penalty sort of thing. Usually that's just more of a, what should it be for somebody who breaks their oath? I don't know. I don't know. I mean, maybe that's more of a question for the legislature in impeaching somebody, but we're not going to hear that anytime soon, because the governor won't allow our legislature into session at all. He's too afraid that they'll stop his state of emergency rule over our state. If he called the legislature in, they could, with a 50% majority vote, they could end the state of emergency and stop all the mask mandates and the stay-at-home orders that we're living under here in West Virginia. This is a good comment. DJ Plass, personal cell phone used while their official capacity is public record. I think that's exactly something that happened here, is that this sheriff's deputy who is acting as bailiff here, apparently, according to the complaint, the JIC statement of charges, did pull out a cell phone and started recording at least part of the search that was happening in the house, even though Matt wasn't allowed to record himself what was going on in his own house. And we haven't seen that video. I know that it's been asked for. It's been requested via FOIA. I think maybe we or Matt requested it. I think maybe the other lawyer involved here requested it. I don't know if the JIC ever got it, but we haven't seen this video. And I believe it was taken on his personal cell phone. So I don't think there's any doubt that it is a public record and is required to be provided. But just the practical issue is where is that cell phone? Does it, has it been wiped like the Mueller's team of investigators when they wiped all their phones? Was it wiped? Does it still exist? Does the video still exist? Was it accidentally deleted? I wouldn't be surprised if we encounter something like that. We definitely are entitled to that video. It should be public record. But if they don't produce the video, then we still testify, like as Matt has told the news media, back when we did an interview at his house, he was able to walk them through the house and show exactly, that they took the pictures off the wall here, they took the DVDs out of here, the judge sat here, she directed people to do this, that, and the other thing. So, we'll still testify to it, but it would be nice to have a video of it if it was recorded. All right. Joe, I mean, I wouldn't ask any, personal, comments about personal cases or questions. If you have those for me, definitely address those, privately. Of course, it looks like you're asking about Florida. And so I don't practice in Florida. I just practice in West Virginia. Tommy Carter, being that the judge admitted of making wrong decisions, will there be a hearing on this, or will this be a guilty plea? I don't think they use the term guilty, because they use the words, respondent for instead of defendant and all that. So I think that the judge has an opportunity to have, hire lawyers and have her lawyers respond in writing to the charges. And I think maybe that's like, a not guilty plea of sorts. And then they, like any other litigation, including criminal cases, the defense lawyer would work with the prosecutor and try to work out a deal. It depends on what the prosecutors want. And the defense lawyers would try to work out the best deal that they can. And, maybe the JIC wants the judge off the bench. Maybe they don't. I don't know. And then so maybe the judge's lawyers can negotiate a way for her to stay on the bench. Maybe they can't. In a lot of these cases, I think, or some of them, sometimes they agree to for the judge to resign. That's something that could happen here, and then it never goes to a hearing. But where a judge who's charged like this does not work out a deal and does not resign, then ultimately it goes to the Supreme Court, the West Virginia Supreme Court, and they ultimately would rule on it. And I presume there would be a hearing on it and then a written decision announcing what happened. So I have no idea, which way this will go, and only time will tell. What is the difference if this were a federal judge? That's a good question. There's only one way to remove a federal judge, and that's impeachment by Congress. So just like they did to Trump, the House of Representatives would have to vote to impeach a federal judge. And most of the prior impeachments we have in American history are mostly of judges. And that's our founding fathers set up the impeachment, mechanism mostly, for judges. And judges are appointed, they serve for, quote, good behavior. So that's been interpreted to mean for life, even Supreme Court justices. So the only way to remove one, including a Supreme Court justice, is through impeachment. So the House of Representatives would vote to impeach. Then there would be a trial in the Senate, and the Senate would vote whether or not, just like they happened, they tried to do to Trump that failed. That's the only way to remove a federal judge. And, that's kind of why they're so insulated from political pressure that you tend to get less political decisions at a federal court than you do in state courts, where the guy writing the decision or the judge making the decision is going to have to run for office. So they might be less likely to rule in favor of a sex offender, for instance, even if they think that person's rights have been violated or maybe is not guilty. There's that pressure where it might be in the back of someone's mind, well, my opponents are going to use this against me in the next election. And that's happened. The judge let out a sex offender, and you can imagine the political ads with that. That pressure is not there in federal court. And I think there's a good aspect to that. But also there's a good aspect to being able to hold judges accountable to the people. In federal court, they're not. Once they're there, except via impeachment. So it's interesting. My personal opinion is that I like the process with federal judges because you need somebody with almost zero political pressure to hold the government, state government, or county or city officials or police officers liable. You have to have somebody who's immune to that pressure. If you have a state level judge, there's a reason I don't file lawsuits against police officers in state courts anymore, anyways, because the first thing that the judge in that county might do or probably will do is just throw it right out, because they work with them, and a lot of judges that they feel like they have some role, as they're sort of like an employer because they're part of the county. You're suing the county in their own courthouse. The judge is a part of that. They're going to kick your case right out. Federal judges, you don't have that same issue. That's why I pretty much exclusively file things in federal court, unless I have a really good reason. For instance, where a state court judge already found, say in a criminal case, that there was a civil rights violation. Well, hell yeah, I'll file the civil lawsuit right in front of that judge. But then the defense lawyers, they remove it to federal court because they don't want it in front of that judge for obvious reasons. All right. Will dealt with family court. How do they get away with ignoring rights more than regular court? I don't. I kind of already went over that. They get away with it for reasons that it's a less formal process, and people perceive it as somehow less serious than, say, a criminal court where you're deciding whether somebody committed murder or something like that. It's still a court. It's still a judicial. It's still a judicial role, and the same rules apply in family court as apply in other courts. But a lot of times they're more relaxed because a lot of people represent themselves in family court. And being a family court judge is difficult. I know it's difficult, and there are a lot of great family court judges out there that have to make lots of unpopular decisions. And I think there's the vast majority of them, I think, do what they believe is best for the children. And maybe that's what this judge was doing, but you can't take it to the max. And again, we weren't dealing with a child here in this case. We're just dealing with insignificant items out of a year-and-a-half-old divorce. But I could see a judge getting carried away in a custody case and wanting to go to a house and see, for himself whether or not it was some of these allegations of child abuse, for instance, were true. I mean, that would be a I think it wouldn't change anything legally, but it would be a more understandable case. The fact that here we're dealing with, such, insignificant items or disputes, it just kind of takes it to another level. Anyway, Matt, I'll go ahead and put you back in the green room here, and I'll wrap things up as I'm getting texts here that I got somewhere to be. But any parting words of wisdom from you?
No wisdom. Just always do what's right. And thank you, John, for taking it. So just keep fighting. This is my court case. Hearing everybody say, "Hey, this family court judge did me wrong. This did me wrong. This person did me wrong." It did fuel me because I knew it wasn't just me. So this is for everybody that's been done wrong in family court. That's it.
Yeah, well, I appreciate it, Matt, and I appreciated the fact that you had the courage to stand up to this judge who was trying to bully you and call her on it. And if you hadn't have done that, it probably would have continued to happen. So, and obviously also having the infinite wisdom to go to the right lawyer to try to get justice. And
absolutely, John. And again, I want to reiterate, and then I'll let you go. If you have a complaint on a judge and it's happened to you, John put the link for you to go to the JIC. If you know a lawyer that searched your house that's supposed to protect your rights, turn them in. It's time to do Operation Cleanup in Raleigh County. That's it.
All right, appreciate it, Matt. So what he's talking about is, and I have put this link up on my website on the civilrightslawyer.com. Let me go share the screen again and get back to it. All right, so there it is. That's civilrightslawyer.com, somewhere on here in a recent post. I think it was the last post. All right. Yeah, the last post. West Virginia Supreme Court releases formal statement of charges against Raleigh County Family Court judge. And if you're interested in this case, I would read this, because I don't know I did some good interviews today, but I don't know if they even, what parts, if any, they actually put on the news, or if it's even available if you don't watch the news live. So if you want to hear kind of my analysis, my thoughts on it, I put it all in writing right here. What the JIC alleged and kind of what my thoughts were on it. I even put a copy of the recording with the opposing lawyer's demand for $5,000 the night before. And I also put a link to one of the local lawyers who originally 6 months ago or so got on TV and claimed that I was wrong, and this was completely normal. It happens all the time and perfectly justifiable. And that was just wrong. Like I said then, that was wrong. He was wrong. I was right. I am right. So I don't know if it's on here. I'm looking for the link to, here it is. Yeah, it's right at the top. All right. So the state has a website, the Judicial Investigation Commission. You can go right on the last post that I made. And if you have a complaint, they may hate me for this, but here's the complaint form. Just click, here's the complaint form, click on it. And anyone can file an ethics complaint against a judge, but there is a time limit. If it's a complaint that's filed more than 2 years after the complaint, after you knew or should have known that a ethical or disciplinary rule was violated, then it's going to be past the 2 years, basically a statute of limitations for it. So it has to have happened in the last 2 years, or you just found out about it, within the past 2 years, basically. So anyone can file it, and it has to pertain to your case, obviously, but you click on it and it takes you right to a form, and there it is. It's a fillable PDF. And if something similar happened to you, file a complaint. And it would be interesting to know, and if you were one of the 10 people who actually had your house searched by this particular judge, that so you're basically mentioned in the statement of charges, I would be really interested in hearing the story, because again, I just find it so bizarre that nobody's attorney stood up and said, like, hold on a freaking second, like, wait, what? Wait, you're going to my client's house? I object to that. What, you don't have any authority to do that. How could you do that? We don't agree to that. That's as easy as it could have been. I mean, I like to think that if I was in that circumstance, that, hell, I might get thrown in jail. I've walked the line close a couple of times when I've been in court, when I just feel like the judge is favoring one side, and especially a criminal case. Criminal cases are very, very stressful, because somebody's liberties on the line, and you have everything on your shoulders. And it's all up to you. You are the one speaking for your client, whether they're paying you or your appointed lawyer. It's your responsibility to speak for your client. If you don't object to things, if you don't make objections, your client waives objections. So prisons are full of people who have been told they're not getting out of prison because they waived, an objection to X, Y, and Z. Well, it wasn't them, it was their lawyer. Obviously, they don't have law degrees. They don't have experience defending criminal trials. They're not trial lawyers. That's what trial lawyers do. And the best trial lawyers, I mean, talk about some, like somebody said the other day when I met up with Marshall Wilson, who's running for governor, and he was a lover of the Constitution. And this is in Putnam County. If you know me, you know that I didn't give any forewarning that I was in Putnam County, but I met with him there, and there was this guy there at his event, and he said, I just want to thank you that, I think that, lawyers, are really kind of like a front lines on the fight for freedom sort of deal. And I said, yeah, well, there's some truth to that. I mean, except for the prosecutors, since they're the ones, filling jails with people. And I'm kind of halfway joking with that, because people like Kamala Harris, that's what they've done their whole career, is they've put people in prisons. They've put people behind cages. But there are a lot of good prosecutors out there as well. And some friends of mine who are prosecutors, they do a lot of good because they're in the position of power, extremely powerful position that you don't even have to get to the defense lawyer because they're exercising their judgment and their discretion to do the right thing. And you never know about it because it never was brought. And so a lot of good gets done by prosecutors, by the good prosecutors. But aggressive prosecutors, and again, we may talk about this next Monday, this particular county is prosecutor been there a long time. And so I've heard has never lost a case. And I'm not sure why that's something you'd be proud of as a prosecutor. But again, that's a discussion. We might spend a little bit of time in this county. Putnam County can have some relief. I'll spend some time in Raleigh County because I know there's a lot of good people there in Raleigh County. I know some police officers who are good guys who are there. I know some good, real good lawyers who are there. And it in the end, people just have to stand up and call people out on things like this. And Matt it was a perfect storm. He could have just complied and not filmed it and not made a big deal about it, and it never would have happened. But he was willing to say, no, you're not getting in my house without a warrant. And that was a game changer. I mean, because then there's no argument for, well, there was consent. Like police sometimes, you don't mind if I search your car, do you? And they're halfway done searching your car, or they have a gun pointed at you. Like, no, sir, I don't mind you search my car. But that's not really voluntary consent. So I mean, there can be gray areas where we can argue about whether or not there was consent, but given who he is and his past experience, he knew what to say. I mean, he did a great job representing himself at the scene in a very difficult situation that I can't imagine, exactly what to do. On another note, speaking of a situation that you've never seen yourself in, I finally had my very first Karen incident this morning. I won't say where I was, but I was in a shop just there for a second. And it's where you're consuming food or beverages. So there's people sitting down without masks all over the place. But while you're physically standing, you're supposed to have a mask according to our dear leader's executive order. Well, there's this couple, one of whom told me that, she was a lawyer, very clearly with a New York accent or somewhere close by. Said, excuse me. Do you have a mask? You do understand that there's a coronavirus out there, and absolutely tried to make this huge scene. And the everyone else in the restaurant working there, and I mean, they were all like cool about it. And I was like, look, just give me this thing. And like, I'll be out of here. I didn't have a mask on me. And they went full Karen on me. I've never personally seen it like this, and I've never had it happen to me. I would have pulled out my phone and it would be a viral Karen video had I pulled out my phone, but I didn't want to cause any drama for anyone else that was caught up in a viral video in the room. I mean, it was unreal. I mean, they kind of, told me I had to get, they were like 10 feet away from me, that I had to back up. I was basically assaulting them, and they had fear in their eyes. I mean, they had been completely brainwashed. I've never seen anything like this before. And of course sounds like come here from New York or New Jersey, possibly. So they're coming for where they had the big outbreaks to Greenbrier County, where I was, where it has only nominally been infected, and yet they're bringing they're going to infect me if anything, basically. But they weren't worried about me getting sick. Yeah, they were worried about themselves getting sick. I mean, it's like they thought I was killing them. I was literally killing them. I've never seen anybody react to anything like this before. I really wish that I could have caught it on video. Had I been somewhere else where I didn't want to embarrass anybody, I probably would have just started filming it, and that probably would have enticed them more. So that was my first Karen incident, and I just had that today. Before I close out here, okay, it looks like Matt already texted me. It looks like somebody's already contacted him. who was one of the other 10 parties that had their house searched. And so I haven't even read the details yet, but so that's one down, 9 more to go. If you're one of these people, let me know your story. I really want to know who the lawyer was who requested the search of your house, and who your lawyer was who didn't represent you properly, in my opinion, by not objecting to it. And again, that's just what is contained in the statement of charges. But I'd like to know, who's who and what's really happened in this place. Yeah, Scott, wearing a mask while walking in and taking it off at a table is like having a pissing section at the pool. I mean, it is. I mean, everyone else in the room, they were just like, oh my God, really? Because I mean, most people were following the rules, and yes, I was breaking the rules. I didn't have a mask on, but had I had one in my pocket, I out of respect for the business owner, I just would have put it on. I wasn't trying to cause any drama, but literally, the reason I went in anyways is because I could see people in the window inside. They didn't have a mask on because they're eating, they're drinking. So I don't think anyone thought it was a big deal because they weren't wearing a mask. Right next to us, there are 3 people sitting at a table without a mask on. And so these people are just flipping out at me. And I say, look, they're right there. They don't have a mask on. And they say, oh, but they're sitting and you're standing. And then the actual Karen, the Todd was the more aggressive one. I mean, he was, I thought he was going to attack me. I mean, that would have turned out very poorly for him. I was just trying to be polite, and I was just sort of smiling. But then his wife started and said, well, I'm a lawyer. And I was like, oh my God, it was kind of funny, if anything else, but it was also sad because that's where we've ended up now. That who would have ever thought that people would be physically almost attacking you as a healthy person to wear a mask? And if you're that scared, you could stay in your basement in New York, or you could have worn a completely protective suit before you walk into the shop. No one has stopped you from being as protective as you want. But if you think that you're going to come to West Virginia and you're going to, you're lucky it was me, just a polite, handsome young lawyer in a suit, and you didn't run into, a good old boy who knows what could have happened. And I'd like to see them go down to McDowell County and go in a shop there and pull that same thing. I would love to see what happens, and I would film that. So thanks for the comment, Scott. Tommy, thanks for. I do appreciate it when people thank me for what I'm doing. It's a lot of what we do as lawyers was we make enemies. We make a lot of enemies in most areas of the law. That's what you're doing in every case. You're making an enemy of somebody. Sometimes I try to treat the other side with respect. And, sometimes I've had people who I've sued come hire me for their case after the fact. So I appreciate that, Tommy. Everyone else, I see that I'm being summoned for dinner. That is my wife telling me that dinner is ready. So I got to go. So thanks for watching. And next Monday night, I think it's going to be 6:30 p.m. Eastern time. Next Monday night, we're going to have a special guest, and we're going to discuss kind of what's going on in this same county from somebody who knows a whole lot more than I do, and somebody who is in a position to fix a lot of things, to do a lot of stuff. So I think that's going to be exciting. And I think you'll, especially if you're interested in that county or you're around there, you're going to want to watch next Monday. So thanks for watching. Remember, freedom is scary, but it shouldn't be. And I direct that specifically to the pleasant Todd and Karen from New York that I met this afternoon. And I would be happy if you join me next week.